All right, guys, since we're taking class time to go over the College Board reading, I think what I'm going to do is post a video of talking about a few Supreme Court cases that have a connection to either Article 1 or Article 2. And this way you can go back and maybe review these SCOTUS cases on your own. I can answer any questions that you have during class, but I just want to kind of maybe go over these 6 cases with you, 6 or 7 cases by the time we get finished. And this way you just have a resource to go back to. So the first one that we're going to talk about is United States versus Curtis Wright Export Group. And this is from 1936. And basically what was going on with this case, this was during Franklin Roosevelt's presidency. And the Congress and President Roosevelt had signed a joint resolution that placed an embargo on any kind of arms shipments to South American countries. And the thing that was going on at the time, that's not going to be on the AP exam, but just so you have a reference point, was something called the Chaco War. And there was an organization called the Curtis Wright Export Group that was indicted, got in trouble for violating this embargo by selling bombers and different fighter planes to the country of Bolivia. Well, the Curtis Wright Export Group tried to defend itself by saying that the embargo and the proclamation was unconstitutional because you had Congress improperly delegating its legislative power to the executive branch. And so they were trying to say that Congress was giving up power that it was supposed to have. Well, the Supreme Court sided with the United States government by saying that the executive branch has supremacy. The federal government has supremacy when it comes to foreign affairs. And so basically if the president had said that there was an embargo placed, if he and Congress said that, they made that decision together. And so the president had plenary, this would mean absolute powers when it comes to foreign issues. So basically Curtis Wright Corporation lost that case. Okay, now one that's a little bit more exciting. We've got Korematsu versus the United States. This is 1944. And some of you know about the Japanese-American internment camps that happened during the Second World War. So we have this American citizen named Fred Korematsu, and he was at the time a citizen of the United States, always a citizen of the United States, born in the United States. But he lived in San Leandro, California. And the United States had issued the Civilian Exclusion Order, number 34, also called Executive Order 9066, so 9066. And this executive order had ordered all Japanese Americans into internment camps during the Second World War, regardless of their citizenship. So Fred Korematsu said that, first of all, he didn't show up. He did not follow the executive order by taking himself to an internment camp. So he said that this was unconstitutional. He said that it violated the Fifth Amendment of the Constitution, due process. He said that he was owed a day in court to see if he actually was a threat to the United States government during the Second World War. Either way, he was arrested. He was convicted. There was never a question raised regarding his loyalty to the United States or anything along those lines. It was merely that he had not followed the executive order. Disappointingly and surprisingly, the Supreme Court justices of the time sided with the United States. And in fact, Justice Hugo Black, said that the need to protect against espionage outweighed Korematsu's individual rights, and also the rights of any other Japanese Americans, so no other people that were interred were able to bring this case back up to overturn it. One of the reasons that this case panned out as it did is because there was actually a report of the court that was held, a report from the Naval Office that was held from the court that indicated that there was no evidence of any Japanese Americans acting as spies or sending signals to the enemy submarines, which is what the government was essentially afraid of. So the SCOTUS had no access to this report. They, out of fear, cited and held up the United States decision to convict Korematsu. Just recently, though, and it was actually in 1983, the United States Supreme Court did overturn this case, and even as recent as 2011, the United States has officially apologized. The Department of Justice filed an official notice that said that the Supreme Court was in error, and therefore the court case cannot be cited as any type of case law to say, well, the U.S. government decided this, and Korematsu versus U.S., so this is what we need to do. Okay, done with Korematsu. Moving on through time. Here we are, 1970. This one is Swan versus Charlotte Mecklenburg Board of Education. And Mecklenburg, the Mecklenburg Board of Education. And this is, like I said, 1970. So this is a few years after the desegregation court case, the foundational case of Brown versus the Board of Education in 1954. So 1954 schools were supposed to be desegregated, but due to segregated housing, due to resistance by local leaders and many schools, there was still a lot of segregation all throughout the 1960s. One of those places that this was still happening was in Charlotte, North Carolina. And in the mid-1960s, less than 5% of African-American children were attending segregated or desegregated schools. Admittedly, busing was used by white officials to maintain this segregation. This even happened in White County, as we've talked about before, all the way up until 1988. But the NAACP, on behalf of one of the students, a 6-year-old child by the last name Swan, sued the Charlotte Mecklenburg School District to make sure that their son was allowed to attend Seviersville Elementary School, which was the closest school to their house. It made sense. At the time, it was one of Charlotte's few integrated schools. The district judge took this court case. He ruled in favor of the Swans, that the schools were in error, that they were not allowing this child to school. The school system tried to push this, tried to appeal to the Supreme Court. Supreme Court sided still with Swan. And so this court case, the reason it's very important is that the busing strategy that a lot of school systems were using at the time to try to avoid certain minority groups was done away with. And so this strategy that the Supreme Court suggested was adopted all over the United States, and it's played an instrumental role in slowly integrating the United States public schools. Okay, 4 years later, 1974, we've got the United States versus Nixon, and so this is right in the middle of the Watergate roundup. You've got President Richard Nixon saying that he was immune from any type of the subpoenas that were being issued, where committees that were being formed to figure out what exactly happened at the Watergate Hotel. He was saying, no, I have executive privilege. I don't have to give you anything because I'm the president, basically. I don't have to do what you tell me to do. These committees were trying to collect information. They were looking for tapes from inside the Oval Office. They were looking for and questioning the president's close aides. As I said, the president continued to say, I've got executive privilege because of national security and because of my confidentiality power. I am entirely immune from any type of judicial review. So the result of this, what do you think? Simply stated, that was a big no. Nixon and no other president can just say, sorry, I can't answer these questions because I'm the president and I don't want to. So what's super important about this case is that it is considered it's a crucial precedent in limiting the power of the United States president. So precedent, not president. It's a crucial precedent. Let's say it's a fundamental benchmark in limiting the power of the president. So in class, we've talked about how the office of the President of the United States has grown tremendously over the past couple of centuries compared to what the original intent was. This court case helps to kind of rein some of that in. Okay, just a couple more here. We're done. Let's talk about INS. INS is in Immigration and Naturalization Services versus CHATA. And Chadha is spelled Chadha. This happened in 1981, and you have Jagdish Rai Chadha, who was a student in the United States. He was born in Kenya to Indian parents. Okay, Kenya did not claim him. India did not claim him. He had a passport from the United Kingdom to study in Ohio as an exchange student. Okay, so we're all over the place here. Basically, though, his visa had expired, and the Attorney General of the United States said that it would be a hardship for Chadha to be deported out of the United States because he really didn't have any legitimate place to go. So the Attorney General was willing to grant an extension. Well, the United States Congress invalidated the Attorney General's ruling, and because of the Immigration and Neutrality Act, which only allowed one house to veto anything from an executive branch official, that being the Attorney General, they said that Chadha had to go. So the question before the court is this, because it's going to be kind of complicated. The question before the court is, did the Immigration and Neutrality Act that said that only one of the two branches of Congress had to give a 2/3 vote in order to veto an executive branch official, does that violate the separation of powers doctrine? Do you need to have more than just one branch of Congress? And the Supreme Court does end up siding with Chadha, saying that, yeah, separation of powers was breached. That's a tremendously low number of people and only one facet of our government, so very myopic, to use one of your literary terms, so very myopic route that would negate the decision of the Attorney General or some other executive branch member. Okay, if that doesn't make sense, let's talk more about it in class. Next court case, we got term limits versus Thornton. This is a really easy one to understand. This is in 1994. And in the state of Arkansas, something happened that had actually been happening in 23 other states, where you had an amendment that was added to the state constitution that denied ballot access to any congressional candidate that already served, in this specific situation, 3 terms. So in other words, this amendment was going to place term limits on how many times people could run for re-election for the U.S. Congress or the U.S. Senate. Now, if you remember the Constitution, Article 1, Section 1, and Article 1, Section 2, and Article 1, Section 3, there are no term limits for members of the House or members of the Senate. But what this amendment was going to do just in Arkansas was say that we understand that this is what the U.S. Constitution says, but for our state, people go into the United States Capitol, we're going to say that you can't serve more than 3 terms. So, as soon as this ballot measure was voted in 1992, there were people that started to question it. And actually, there was a lady a member from the League of Women Voters named Bobby Hill, who did sue the state court and said that this was unconstitutional. It went beyond the specific constitutional limits that were placed by James Madison. And the Supreme Court sided with her and said that that's kind of crazy that a state would expect of the United States government more than what's outlined in the rule book for the United States government, the Constitution. So states cannot impose qualifications for prospective members of the United States Congress that are stricter than those in the Constitution. So not only did this invalidate congressional term limits in Arkansas, it also did in the other 23 states. So it's a pretty massive case. Okay, this brings us to 1997. So what we have in 1997 is Clinton versus the city of New York. There was this thing in 96 called the line item veto act, and this was going to allow the president of the United States to specifically cancel or make void any provisions on appropriation bills. So if a bill for a city said, we're going to take this money and do this with it, the president could go through and say, no, not going to do this, not going to do this because of executive privilege. So the question before the Supreme Court was whether the line item veto, granted in this line item veto act of 1996, does it violate the presentment clause of the United States Constitution? Now you might be sitting there wondering, what is the presentment clause? I hope you're wondering that. And if you did wonder that, that's a great question. If you take open your pocket constitutions and you flip to Article 1, Section 7, if you look at clauses 2 and 3 of Article 1, Section 7, you'll see that the United States Constitution specifically outlines the federal legislative procedure for which bills originated in Congress become federal laws in the United States. So it's the process of Congress doing this, not the president, okay? This line item veto act impermissibly, so in other words, it should not have, it gave the President of the United States the power to amend or repeal parts of statutes that had been passed from the United States Congress. And so the Supreme Court said this overreaches, this allows the president to overreach. It allows the president to breach the separation of powers. It doesn't maintain that. It gives the president way too much power. So they said no more line item veto act. We have to draw the president's power back in so that he can't go through and look at what Congress has set up and say, no. The president is there to execute, not to execute the law, not to create or decide what laws he does and does not want to follow through his different departments. Okay, so I hope you got that. I hope that those 6 Supreme Court cases that, 7 actually, those 7 Supreme Court cases that line up specifically with either Article 1 of the Constitution or Article 2 of the Constitution make sense. Like I said, if something's still kind of hazy up there, let's talk about it in class, but come back to this in case you have any refresher type questions for these cases. All right, guys, until I see you in class again, signing off. Have a good night.